Hello, everyone. I'm here today with attorney Thomas Graycheck of Lakeland, Florida, and it's a pleasure to be with you today. Mr. Graycheck, would you please introduce yourself to the folks out there?
Hello, everybody. I'm attorney Tom Graycheck. I'm a trial attorney here in Lakeland, Florida, and I practice throughout the state of Florida.
A lot of my viewers that I have on YouTube and some of the correctional sites as well, they have some questions, and they're basic questions, but for some reason a lot of people don't seem to follow the rules that attorneys ask. So if you're accused of a crime, what is your best advice when approached by law enforcement and they start to ask you a number of questions? What do you tell your clients to do immediately?
Well, the number one thing you want to do is your stress level goes up. And whenever anybody's stress level goes up, their ability to process information goes down. So what you want to do is take a breath so that you're thinking clearly, because that's what the police want. They want you to be excited, confuse you, or emotional so that you're not thinking clearly, you're not processing information. So the first thing to do, take a breath. Just like if you were in a car accident, what happened? Take a breath, make sure everybody's okay in the car. That's the first thing to do.
Now, are there questions that you have told your clients it's okay to answer to law enforcement? Like, what is your name? Let me see your driver's license. Questions like that. Are they okay to answer, and do you recommend they answer those questions?
You get into some gray areas. Some attorneys, under some certain circumstances, the police can say, I need to see your ID, your registration. If you're driving a vehicle, you have to prove that your car's registered and insured, so the officer can't ask for those documents. But the less you answer is typically the better for you, because let's look at it and they say, this one's a great one that actually happened in a case. So they come to you, Gary, and they go, Gary, where were you? We think you're involved in this and everything, but we want to clear you. We want to clear you. So, Gary, where were you 3 weeks ago on Tuesday? And for example, let's say you were at your mother at the nursing home, right? So Gary I was at my mother's house. Every Tuesday I go see my mother at the nursing home, right? And so the police go, okay, thanks for talking to us, Gary. And then they go, because they're doing good police work. What would you do if you're a police officer? And
I want to verify your story, so I'm going to go to the nursing home and see that you checked in that day, how long you were there, what time you checked in, what time you checked out.
And then what happens is they go and check it out, and what they find out is 3 weeks ago on Tuesday, there was a breakout. They had an illness running in the nursing home, and they shut it down, and there are no visitors. How does that make you look, Gary?
That makes you look like you made a false statement to law enforcement, and you're trying to cover up for where you were that day.
Right, and all you did was made a simple mistake. So you're talking about, wait, Tuesday 3 weeks ago, and I always go to and then it ends up being, wait. Now that I know it's important, how important it is, just like the police double check their facts, you would go, wait a second, let me double check my facts, make sure where I am. Right. So now, not only did you, give a wrong alibi, but now you're a liar. So why does anybody believe anything else you say?
Yeah, that is a very good point. And so many people do that because they're excited, they're nervous, they want to give the right answer, but being nervous, you could real easily give the wrong answer.
That is why the number one thing, again, is when I went to is, as your stress level rises, your ability to process information goes down, because you're starting to think, wait a second, where was I? What is it? Am I under, And so that's one of the things when I'm picking a jury, the first thing I want them to do is go, hey, everybody, relax. Everything's going to be okay. We're going to explain how to do things. Just like when your first day of school, when you had, you have kids, and when they went to school, were they nervous? Were they, and what did you do before you when you took your daughter to school?
Right. You always talk to your daughter, tell her to be safe, give her the directions and guidance you hope is correct for her to make it through the school day.
And what does the school do now? Orientation. So you go to the school before the school day with your parents, and then they walk you through so that the kids are not stressed when they're on their own. Same thing with your daughter's married, right?
Right.
And so did you have, she had a wedding?
Correct.
Did you have a wedding rehearsal?
Yes, we did.
Why?
we wanted to make sure that it was done correctly without mistakes and everything went smooth, because that's one of the biggest days of your lives.
And that's what you're doing. The same thing with the police is you're removing the stress. So if something came up in the wedding, you're like a glitch. Let's say that the flower girl, she goes and runs down the other way. Are you going to panic, or everyone's going to have a laugh?
Right.
And so that's the same thing, is that the police come in to talk to you. You don't have to make a statement to them, and you go, wait a second, call my lawyer. I want a lawyer, and you're always entitled to one. And they'll give you that opportunity. And that's what you want to do, is always talk to a lawyer first. Whether, you don't know if you're just a witness or if somehow you're a co-conspirator or a co-defendant, and then they start looking at you. And they might not, let's take a look at the example with the nursing home. They didn't think anything about you, and they're just checking, for some background information. And then you give them a false alibi that's not truthful. Now that focus is going to shift on you, and then it's like, well, wait a second, how did I get myself into this?
Now, there is something that I've always told people, and a lot of people have this mindset. I know 100% I did not do this crime. I know 100% I'm being falsely accused. So I am not afraid to talk to the police and answer their questions. What would you tell them? Why should they not answer the questions, even if they know they're 100% innocent?
That's one of the best questions ever. The reason being is that a lot of people think, oh, where's the video? Oh, show me the pictures. Show me, there's no evidence against me. But here's one right here. Go tell them, I didn't hit you.
All right.
And you're going to say I did.
Right.
And that's what it's about. It's Gary saying that I hit him, and I go, I didn't. And the jury decides which one of us to believe.
Right.
And so it's really important in that just because 100% not guilty, didn't do it, doesn't mean that talking to the police is going to help you. Go back to the example, and the person in the battery, you say, oh, Tom hit me on Wednesday. And then you talk to the police, and you start going, yeah, I was around him, and you start corroborating the facts. So here's a big one we used to do to tell people. It is not a crime to be at the scene, merely at the scene. The scene of the crime is insufficient. So if Gary tells me, he says, you know what, Tom, I'm going to go rob a bank on Tuesday. And I'm like, this sounds exciting. I'm going to videotape it or TikTok it, or I just want to see it, right? And so I go and videotape it. It's not a crime for me. But they come to Gary later, and they go to him, and there's a mix-up. You didn't rob the bank. There's a mix-up. And they go, Gary, did you go to the bank on Tuesday? You say,
yes, I was there.
And when you went to the bank, did you have on this nice green jacket? You're dressed nicer than me today.
Yes, I did.
And then you went over to the counter, and you got a piece of paper, and you wrote on it, right?
Correct.
And that was because the police aren't going to ask this, because they don't ask all the questions. They just want the questions that are going to clear the crime.
Right.
And so what you did was you went over and got a deposit slip or something, right?
Right.
But you went over and you got a piece of paper and you wrote on it. Correct?
Correct. I sure did.
And then you went to the very first teller, not the one way in the back, but the one closest to the exit, right?
Correct, I did.
And you handed her that note, right?
Yes, I did.
And then at some point you had to reach in your pocket. And so you're thinking back going, wait a second, she wanted an ID or something, or, so you reached in your pocket. You remember that? We have it on video, Gary.
Correct. I had to get my identification.
And that's when you said to her, I have a gun in my pocket and give me all your money or I'm going to shoot you, right?
No, I did not say that.
So you denied the crime, right?
Yes, I've denied the crime.
But what did you do as far as prior to denying the crime? You corroborated every single step along the way. So when you get to court and the jury goes, and officer, did he go to the bank on that day? Yes, he went to the bank on that day. And did he wear these clothing? And did he go to this? And did he do that? And did he go up to that teller, the one that's in court today? Yes, yes. And then what happened? Well, he denied the crime. Everybody denies it. But you've now given credibility to the other witness to back up what they say.
I probably just collaborated 90%, except the final, most important part. I say, no, I did not commit the crime. But they've got 90%.
Right, and then
Yeah.
and then let's say it is a your word against he, she. You know, he versus she, Johnny Depp versus Amber Heard.
Right.
And now you've admitted 90% of, 99% you get to let, but I didn't do the crime, the actual act. But everything else that the witness against me said is true, except that one part. And the jury's already on the path because they're the one deciding your fate. And they're going, well, they told the truth there, they told the truth there, they know this detail, they know that detail. It's got to be true. That's why you don't talk to the police.
And that's what I tell a lot of the folks that talk to me, because I'm involved with a lot of correctional officers. That's what I was for 28.8 years, and they get accused of false allegations all the time made against correctional officers. And that's one reason I wanted you to answer that question, because if I'm wrong, let me know. But I tell them that we can be our worst enemy, even though we're innocent and we don't mean to say anything wrong. We can be our worst enemy in our own case.
I had a case recently, and we'll do a video on it. It's going to be the biggest crime from going forward, and it's written threats, either on Facebook or you text somebody and you write a threat. I write a threat. This is the law in Florida now. If I tell Gary, I go, I'm going to shoot Mr. Smith, that is a written threat, and under the law, you're guilty of a second-degree felony, 15 years in prison. So the next thing is when you go, the police come to you, for some reason they're investigating Gary for something totally different. They get access to his text messages or instant messages, and then they come to me and go, well, look, we're going to get another crime out of this. And so they go to me and they say, do you know Gary? Yeah, I know Gary. And do you text with Gary? Yeah, I text with Gary. And are you friends with him on Facebook or Snapchat and however you text with him? Yeah. And when you do that with Gary, do you go under Tom Grayjack, greatest lawyer ever? Of course I go under that signal. And so, and you text Gary on a regular basis? Yeah, sure. And you texted him last month? Sure. A couple months ago? Sure. What's this all about, officer? Well, you texted him that you were going to shoot Mr. Smith. I'm like, what? I've already walked myself down the path, and it's just, now I got to deny the actual crime, but corroborate.
Once again, right in there. And I'm so glad you brought that up, because I'm always talking to officers around the country that you may just be joking about anything, but that social media, those jokes and those texts can bury you. Another example of being your own worst enemy.
I don't know if they're still doing it, but one of our private investigators, what they always wanted to do was get these, they call MTM or MSN messages, where there's a separate way officers could text each other. And you'd be shocked when they think nobody's ever going to see them, and think it's just between the officers, and that trail is there, how dangerous that can be to the case.
Well, I'll go ahead and say it because I've done it in other videos. One example that I can give is officers are upset because an inmate struck them.
Stress levels up.
Right, they're upset right now, so they get on their social media right after something happens with a use of force with an inmate, and they say, I'm going to kick that inmate's ass, and I'm going to put him in the hospital, and things like that go out. They're saying it at the height of their stress level, their anger, their excitement level, and now it's out there on social media, and you can't drag that back now.
And that's kind of one of the problems, and I should probably get, well, I don't have the small one, but tone, stress, the heat of the moment, when you're sitting there and you're venting. So if you're writing a written threat to somebody and you're just venting, that's your defense to the jury. That's the only defense you have in that case, and because they have to prove what's called mens rea. And so you then have to put a jury or hearing officer, whoever's deciding your fate, into that same heat of the moment emotional battle. And when you don't have the tone and you don't have the context, that's what, as a trial attorney, you have to be able to do, is you have to put people into that situation, go look, and get them to feel the same way. That's part of the problem with every criminal case, because every juror comes in and goes, well, I would never do that. And you have to go and give them a real life example where they relate to it and they go, Oh, okay, I get it. That's why storytelling is so important, which you're big on, because how many books have you written now?
3.
All bestsellers on Amazon.
And I have a 4th book out with the first traditional publisher ever, which you reviewed the contract for me, and they said it should be out this fall.
Fantastic. Yeah. And so storytelling is big, and that's part of what you do as a trial attorney. But what you're going to have to do in that instance with somebody who's just venting and saying, you know, I just got to get it off my chest and then I'm okay. So when I go back and see that guy in the prison the next day, I'm not, you know, going to go off. I'm not going to have a problem with him, is through storytelling and using as like. That's why we teach kids stories. And you use that to put the person who's going to be judging you into your shoes. But you don't want to be putting that out there. It's one of those, think twice before you hit click, you know, send or post it up on there. And the worst part is the inmate doesn't have to see it. As long as someone else does, someone who doesn't like you at work, someone who somehow got access to it, somebody shares the post, someone you don't know, or an axe to grind, or your ex-wife gets mad at you, you got a bad divorce, and she has access to it, and now she turns it over to the police. And it's one of those, we live in this society now, unfortunately, we didn't grow up, where there's all this texting and social media where you really, really got to be careful what you put up there.
Yes, everything you say or do now, at work, at home, on your social media, is subject to getting it in the outer space and being able to be retrieved 3, 4, 5, 6 years later at any time and used against you. The perfect example is a divorce case. The man or the woman, now all of a sudden 6 years later, I'm going to pull up this social media on you because now I don't love you anymore. And you know.
Here's the other problem when you post things on video or you text somebody. You ever text your wife or somebody and then all of a sudden the text you got back, they were ticked off at you and mad at you? And it's because they didn't understand what you meant. You go, oh, no, that's what I meant. I didn't mean that, baby. Whoa. Wait, you're seeing another woman? No. So you got to remember when you go back in time to these text messages or these emails, you either forget the context or worse is something along this line, is that, repeat after me, Gary. I did that. Confession, right? That's what everybody thinks. Confession.
Right.
And so, what did you do? What's that?
I corrected an error, or I painted a house, or planted a garden. I'm not talking about a crime.
Right, but me as the person, you know, accusing you, and I did that becomes whatever I want.
Whatever you want it to be. Right.
And so here's another thing. When you said you just repeated after me, very robotic, because that's what I asked you to do. But if someone came up to you and they said, you know what you did? You went, you robbed that old lady and everything. And now say I did that, but say it like I don't believe it. There's no way I did that.
I did that?
Exactly. So there, now when you just said that, this is really important. When you said it now, you went, I did that, like you're crazy. You must have me confused with someone because you put the stress on I. If you said, I did that, like you're crazy, now you're talking about the act, whatever it is. True case, it was a sex case, lost the trial. That's the other thing. If an attorney tells you that they win every trial or don't worry about your case, there are no guarantees. You know, there's death and taxes. That's all you have. And there's no guarantee a lawyer's going to win your case. The one that was in today, and I go, look, I've won the last 7 trials, 15-minute not guilty verdicts or less. But it doesn't mean we're going to win your case. Your case, your facts, your jury is different than everybody else's jury. And that's why no lawyer can predict the future, no judge can predict the future, no prosecutor can. And so you got to protect yourself up front and going, you know, not talking to the police can be taken out of context.
Best advice ever. And when an attorney tells me, I can't guarantee you're going to win your case, well, I feel good right up front. I think there are some people who think, no, you're supposed to tell me I'm going to win this case for sure. But if you tell them that, you're not telling the truth. You're being dishonest. So A good attorney is going to tell you, I cannot guarantee you'll win the case. We're going to fight hard for you, and here's where you're at, and then you explain
Yeah.
where you think they are.
And how many years were you a bailiff in court?
Now, my last 10 years of my career, I was a bailiff in the courtroom, so I sat through a lot of jury trials.
Right. So you've seen them, and juries can be unpredictable.
Very unpredictable.
When they go out the door, we in the courtroom might think, oh, it's going this way. And then
Mhm.
they surprise us even after we sat through the entire trial. We're like, look at Johnny Depp and Amber Heard. The jury comes back, fines for Johnny Depp, and then they don't put any damages in,
Right. No damages. Yeah.
Yeah. So it's one where, and then you see too with lawyers and whether they know what they're doing in the courtroom. Some you're like, man, they're lost, or they look disheveled, or they get lost in their thoughts, or checking their papers and everything. It's a big difference.
I have to say this, and I will never give names or anything, but as bailiffs, we see all the attorneys coming through, right? And lots of times after something is over with, we'll go, oh my God, I'm never going to refer that attorney to anybody.
And you feel bad.
Oh, I'd feel bad for somebody to have that attorney to defend them,
That's one of the hardest things when people come to you and they go, hey, send me to a good family law attorney, that if you're not actually sitting in there and watching them, or them going through and going, here's a case I had and why we won it. And again, prior case results don't mean they're going to win yours, but they know
Right.
how to win. They know how to get to the result. So anytime you go meet with someone, you should walk out with a strategy and go, okay, now I know how I'm going to win this case. And the lawyer should be tough on you and call you out. You're like, I thought you were on my side. I get that a lot. I go, look, before I can get on your side, we got to work through how things are misperceived. What's good about your case is great. We're going to get to it. But what's bad about it, because you got to move everything from the bad column over to the good column. And how you're going to explain that fits into my story of what actually happened. Because otherwise, if you got an outlier of a bad fact, you're not going to go anywhere. And you need to know that from day one. That's part of the problem, is setting up expectations up front.
And that was one of my questions I was going to ask you. I'm your client, and and that's part, you answered part of it. How are you going to prepare me for court? What are you going to tell me about my case? And you answered part of that. Now, if you know your client has the possibility, or even if they don't, but you still want to have them prepared to testify, do you do things with your client to get them ready?
Yeah, we're doing it more and more. The last few trials, what we've done is the tennis ball example. So what I'll do is I'll stand up and I'll ask a question, and I have the tennis ball, and then bounce the tennis ball to my client, who'd be you sitting in the chair. So if I'm...
This is not in the courtroom, this is in your office.
In my office.
Okay.
And so let's say that the camera you're looking in, Gary, is where I'd be standing.
Okay.
I'm standing there and I ask you a question, what street were you on? I then bounce the ball to you, and then we'll say the jury is over against that wall. You would then take the ball and bounce. We'll have somebody sitting in the jury area. So when you turn, do it like, just pretend you're doing it. You would turn your body and you would bounce it so that you're facing the jurors.
Right.
So when you're presenting to somebody, you want eye contact, not overdo it like Amber Heard. She got crazy, way overdid the eye contact. But what you want to do is, the psychological studies show that when you turn your torso to face somebody, you're much more credible than if you're looking straight ahead and your audience is over there.
Right.
And so that's what we've been doing, is training them, because it builds muscle memory. And so the muscle memory, like sports, it's the same thing. And what it does too is it starts to relax the client. The number one thing, again, your stress level high, ability to process information low. You got someone who's got the biggest day of their life. They're like, man, this is life or death for me. This is my future. I can't have a felony. I can't have a DUI, or a personal injury case, that I need this money to, pay my future medical bills. And so the muscle memory in doing that puts the client at ease, because last trial, I told my client, I go, look, it's all on your shoulders. He was so tensed up. I'm like, you just got to relax. And we picked the jury, or we're in the middle of picking it, and then a witness didn't show up. So the prosecutor asked for a continuance, and we had to come back next month. And my client was just visibly, you could see the stress was gone from him, because he had done it before. And then he turned to me and he said, Mr. Grayjack, he goes, that really hit home. I finally took your advice to heart, and I said, you know what? I'm innocent, and I got nothing to fear. And he goes, I just feel so much better, and thank you. And that's, people read body language.
Exactly. And while you're on that point, for my viewers in the corrections field, I tell them the same thing when they're testifying in court. You may be a defense attorney questioning the officer. The officer just testified to what he saw, what he did, why he did it. Now you're going to go up and question them. But I have always told them, look at the jury. You can look at the attorney when they're asking the question. And then when you answer the question, I always tell them, turn to the jury and answer the question to the jury.
Right, yeah.
Because that's who you want the answer. That's your important people right there, the jury.
We had this was the last trial too, same one. And so the jury was over here, and the prosecutor table's over there. And this is what the police officer kept doing. And I went, I called them out. They'll try it. But why are you looking over there? Prosecutor ain't got no answers. They weren't at the scene.
Was not looking at the jury.
Not looking at.
Just looking everywhere else.
No, he's looking at the prosecutor.
At the prosecutor.
Help me with this question.
Okay.
Oh, what am I supposed to say? What am I supposed to do? Jury's not going to trust him.
No, you want to be. I always say that as well. Thank you for that example. I always say, be prepared. Know what you wrote in your report. Know what you did, and don't go in there half blind.
Don't make stuff up.
And don't do that.
You're not going to win your case on the stand. And so you're going to lose it, though.
Right.
You won't win it there. You'll lose it because the truth will set you free. And so everyone goes, you win these cases, and the toughest officers in a criminal case are the ones who just come and tell the truth.
Right.
They're not trying to elaborate, stretch the truth, exaggerate. They just come in and go, yes, no. And if it's a question that hurts the prosecution's case, I tell my clients all the time, I go, just tell the truth. They go, yeah, but that's a bad answer. I go, don't worry about it. And they go, but it's bad. I go, no case is perfect. There's good and bad to every case, but we're going to fit it in, and we're going to explain why that is bad. It's not a bad fact. But if you start trying to do it on the stand, people know you're not telling the truth, you're not forthcoming, and then they don't believe you.
Well, as a felony probation officer and a former 12-year investigator for internal affairs for the state of Florida, and then, the jail and the bailiff, I had to testify in county, state, and 2 federal trials. And I just answered the question straight out. They asked me the question. I did not go in there trying to beef up my testimony with extras. And I always tell everybody, don't add to it. Don't distract from it either. Just tell the truth, and your testimony will go so much easier. And as a bailiff, we could sit there and watch a lot of these officers testifying, and you would know the ones that came in every time and say, well, this guy or woman, this man or woman, they're just going to tell it like it is. And then you saw the ones that were always fishing for a super answer that was going to just knock everybody out of their seat, and they made themselves look bad.
Yeah. If someone comes to you and they ask you a simple question, what color was the light?
Yeah.
And you go, it was green. And then you go, well, where were you when you're saying the light was green? Where were you positioned on the street? And they don't want to answer it, and they're like, well, I'm not answering that question, or you gotta understand, I was at this corner and then I was at that corner, or I had this going. Just answer the question, because you're gonna give me something as an attorney to open you up. I'm not gonna say it on the video because I save it for my trial techniques, but I can embarrass you really, really fast when you won't answer my question. You saw Camille on the Amber Heard trial, that Amber Heard would go off on these tangents and looking at the jury very weird, and Camille would just go, who did a tremendous job, would just go, Miss Heard, please answer my question. And you said it enough, the jury got it. They're like, you won't answer.
Right.
And you have kids.
Juries, we've always told everybody in the courthouse that have to speak to a jury. Jurors are way smarter than people give credit for. These people are a group of people from all walks of knowledge and life. they know, they see, they can tell when you're telling the truth, and they can tell when you're lying.
That is one, and that's why being a bailiff is huge. I tell attorneys too, you better go watch other attorneys try a case, because you'll see things you do in trial and you're like, man, that does not look good. I've changed because I've seen attorneys, doing the same thing as me, going, that's not nice. And what you brought up is huge. And that's how you know Gary has a lot of experience, because juries are incredibly smart. When you put a group together with their experiences, you got to remember, there's parts of a trial even I miss when a witness says something, or even answering my question, because sometimes you do get ahead of yourself. Jurors don't miss it. You got 6 eyes and ears on that, writing notes, and what you said was really important, is their life experiences are going to make a huge difference, because something a witness says is going to stick with them more than it would me. And that's why too, if I'm at Publix, I'm at Walmart, I just start asking people, about court cases or current clients. I go, hey, show you a video. What do you think of this video?
Right.
So I can get their feedback, because I don't have the same experiences as you do. And your approach to, if you saw a fight, would be different than my experiences based on me and how I view a fight.
Right.
And that's the same thing with, where you're with the prison,
Right.
And what's happening there.
Yeah, it's a very interesting topic to me, and I think that what we're discussing today, whether you're a civilian, as us law enforcement call them, civilians, and don't have anything to do with law enforcement, this is all good knowledge for you in case something ever happens where you're put in a bad spot. And if you are a defendant, you need to hear this stuff. If you're a law enforcement officer, correctional officer, you need to hear this stuff. It's just all around good information for any human being to take in. And, you think, okay, I don't really worry about it now, and then you get in trouble. You're going to wish you took notes on this video today.
So the parents will come in, and then they have a juvenile get in trouble. And so I'll tell them, I go, man, let's say it's petty theft, just doing something stupid we do as kids, steal a candy bar or something from, the store. And I go, man, this is the best thing that ever happened to your kid. And the parents get mad at me. I go, whoa, whoa, whoa. I go, look, you're going to learn everything we're talking about on the video about, hey, can I search you? No, don't talk to, don't let the police search you unless they have probable cause and a warrant, then you do. Don't talk to the police, because you want to talk to a lawyer first. One of the keys is you don't know what your defense is, and sometimes we have to research the law too ourselves to go, what defense fits, because not what you might think at first is going to be a defense to an allegation might not work, because there's case law against it. But learn that the police aren't always your friend. The investigator is going after someone in a prison because someone made an act, saying, oh, he did this to me or he did that to me. You got to protect yourself, because you got someone who's looking to clear a case, put a notch on the belt. Maybe they don't like you. Maybe. Have you ever been somewhere at a party? You're like, you know what? I don't like that guy. You met him 2 seconds, but you made that judgment. So what if the person investigating you that doesn't know you doesn't like you? How are they going to view your case?
And I would pray that
Right.
investigators are unbiased and fair, impartial. That's what you're supposed to do. But look, from doing all this for 38 years in government, some people are going to get mad at me, but unfortunately there are some vindictive, I'm going to get you investigators out there. If you get one like that, they're going to try everything they can to get you to stumble and fall. We just talked earlier in the video about the 90% buildup,
Yeah, and everybody's human. There are clients, I won't take their cases, because I talk to them and they go, oh, we're doing this, or I don't get along with them, and I'm like, it's just not going to work. And so I won't take their case. So it's same thing happens if someone's investigating. Just something could, if you're not receptive to it or you don't take it in the right light, you're going to have a problem when you're the focus of an investigation.
And you don't want to be one-sided, like guilty, 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 guilty. You have to go down the middle. I tell all investigators, you have to go down the middle. I know you may have a lot of evidence leaning towards guilt, but you have to do a fair and impartial investigation, because what if you miss this piece of evidence over here that actually shows that's not the only person involved, or it's actually a lesser crime than what you're saying it is, and you can't let that happen.
Or that you find out the person who's making the allegation against you, that they have a bias, an agenda, or a motive to get you in trouble.
Right.
And that's the same way when you're doing criminal defense. You got to look at the good and you got to look at the bad, and you can't miss things. Here's one that you just brought up. Everybody comes in my office. They're like, cops didn't even talk to me. They just arrested me. And that happens on almost, I'd say 99% of the domestic violence cases. The reason is, and a lot of times it's the female. We're seeing that change, but it's whoever calls the police first. And if you call the police first, well, you're my victim, because why else would you be calling me? And it's a race to the phone sometimes. But then my client will come in and go, they didn't even ask me what happened. They just arrested me. And I'll let you explain the law enforcement side of that part of why they do it that way.
Well, in many cases, it's just like when an injunction is placed, or someone files an injunction, and you think, oh my God, that injunction is so bogus. But the judge wants to be just cautious. We don't want to find someone. Let's say the judge says, I refuse the injunction, and then that person is killed the next day. They want to side on the error of caution for safety of everyone. That's kind of like the same thing when you go to a house in a domestic violence. The officers trying to side on the error of caution because they don't want to be responsible for leaving that house and someone gets hurt. And unfortunately, we see more and more, it's like, let's arrest them on these domestic violence and let the courts fight it out, unfortunately. But it used to be back in the day, the officer had a lot of discretion on whether or not.
Right.
But now that discretion's been taken away pretty much.
Here's another problem people don't realize. Even if you gave your statement to the officer, it's only going to hurt you. It cannot help you. Here's why. One, he's already made up his mind, because he's got it's basically an unwritten policy, or sometimes there is a policy, that someone's going to jail on a domestic violence out of caution. And the officer's like, all right, well, someone's going. I got enough from this witness, my alleged victim, so I'm going to make the arrest. And if I start going through and I get the defendant's story, the person who's getting arrested, well, now I got a problem, and which one's true or not, and then I got to go back to my victim, and you want to clear the case, remove the danger, and get him out of the house. But here's the biggest one people do not understand. Self-serving statements are not admissible in court for defendants. So when you tell the officer at the scene, I didn't do it, and I come into court and the officer's on the stand and I go, an officer, when you arrested my client, what did he say? I can't ask that, because when they're not allowed to say, I didn't do it. Self-serving statements are inadmissible. So even if you told the cop I didn't do it, it wouldn't come in.
So we're back to square one at the beginning of the video. Don't say anything. Get an attorney and go from there and follow your attorney's advice.
Yeah, because why get something that an officer might not write down clearly, might make a mistake, might write a pronoun wrong, the stress, what word are you stressing? Yeah, I did that, but I didn't do this. Well, what's this and that? That's up to the officer. I had a guy, this one's hilarious. Not hilarious, but he's coming home from Publix, and the two guys don't get in the neighborhood. You don't mow your lawn, your dog poops on my lawn, rah, 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 right? And so the guy's in a golf cart, the other guy's in a station wagon. So as they come at each other, the guy in the golf cart says, I'm going to play chicken, comes right at him. And so the guy in the station wagon is going to kill him, right? So what's he do? He swerves out of the way. He goes, damn you, and he goes home. Well, the golf cart guy, he's smart. He's street smart. So what does he do? He runs home and calls cops, right? And so now he's the victim. He called up, and he's in a golf cart. He's like, look, I'm 72 years old, and I'm driving my golf cart around. That guy don't like me. He tried to run me over in his station wagon. So the police come out, and then they ask him, and they go, hey, you see Mr. Smith earlier in the day? And what do you say?
Yes, I did.
And, did you swerve?
Well, I had to swerve.
All right. Put your hands behind your back, and you're under arrest for aggravated assault with a deadly weapon, carries a 3-year minimum mandatory prison sentence. And so that case got dismissed. But when he said I had to swerve at him, yeah, I swerved. And I asked you if you swerved to the left. You answered I swerved to the right.
Right.
to get out of the way. I'm like, you went into the way because I believe
as soon as you said I swerved, that's it. They stopped.
And you confessed.
Yeah.
You know?
And that the whole story is not out there until you get your attorney to straighten it out.
Right, and that case was one that went away quickly, but that's why you don't talk to the police. There's just too many things. And the other thing, I'm pro video. I think that we need body cams and dash cams, and I know the number one reason always, there's two number one reasons: cost, and then the other one is out of respect for victims, so that they don't get caught in camera on some compromising or embarrassing position through no fault of their own. But there's an easy way around that. You redact that part of the video.
Right. If it goes to court or out, the judge can order a redaction and not allow that in the court, right?
Right. Yeah. You just go, okay, well, that part where this happened with our poor victim, we're just going to cut it out. It's not going to be released to the press. It's not going to be played in court. We're just not. It's as if it doesn't exist.
And that's a good answer, because there's a lot of talk in corrections now about getting body cams and things like that. And a lot of people ask that question: is everything going to be allowed out in public? The Sunshine Law, the Public Records Law.
There's exceptions in place, and then you can't just go in and say, I want a video, because if it's part of the pending investigation, and this is the other big thing, people don't understand what a pending investigation is under the law. And sometimes we as attorneys are surprised, how'd they get that video? Because I don't even have it yet, and it's my client, and I'm watching it on the news. Is that a pending investigation the district courts of appeal in Florida have held is not until the case is over by verdict, either dropped or a verdict. So they can withhold that video from the public because it's an open case, and that's considered a pending investigation, even though there's really no investigation being done. So there's laws in place that protect those people already. That might be one where you don't want it to get out. To me, though, fairness. You want to be treated fair. You want to know exactly what the person said. And I think it protects law enforcement, because that's what you're talking about, is you got a lot of people in prison. There's a reason they're there, but majority there's a reason they're there.
Right.
And so do you trust them, or do you want, a body cam to, go, hey, here's really what was going on. There's your context.
I myself wouldn't have a problem with a body cam. I mean, if I'm going to go into my job and do it correctly, then I don't have any worry about a body cam being on there. Actually, there's controversy on both sides among officers that I've talked to. Some of them like it because they said it'll protect me from false allegations. Right. I mean, now I'm protected. I have the evidence on my body cam. And others are like, no, it'll be used against us for every little thing we say or do. It's a 50-50 thing right now.
Right. I think, though, like the big one against it is cost, where they go, oh, it's a cost to get the equipment to save it. You're going to save so much money
on lawsuits,
trials, and your faith in the justice system, where you go, look on TikTok. I wouldn't believe it happened unless I saw that video on YouTube or, someone posting it. And that's what you're gaining, is trust in law enforcement, because that's the other thing you're hearing now with the latest thing with the school shooting in Texas, and now they're saying officers didn't rush in, or and so when you have a video and you go, look what this officer went through. They just had the Pasco shooting, where all of a sudden you're hearing shots just ring out, and so you're like, yeah, officer, go defend yourself.
Right.
And that's why I think the faith that you have in your justice system to know you're going to be treated fairly is huge. Oh yeah, you remember before I turned on the audio recording, I read your Miranda, and you understood those, right? You're okay? Yeah. Well, how do we know that he read the correct Miranda?
And the agency that I work for, the Inspector General in Florida, we had to read Miranda on tape. And then we had a form that they signed. So now, when my case, if it ever went to court, I've got the Miranda being read on tape, and they signed a paper. But there's a lot of agencies that don't do that.
Right. And here's a big thing. I don't know why you wouldn't do it on video or audio or video, because as much and everything we've been saying, the whole theme throughout this is don't talk to the police. These dummies are going to talk to the police anyways. They're like afraid it's going to chill them. They're not going to talk. They're going to talk.
Yep.
You know?
Yep. And the best thing, and if you don't get anything else, but please, hopefully you got a lot out of this today. If you don't get anything else, and I tell this to officers all the time as well, with so many allegations coming against officers on the street and in the prisons, you have that right to counsel. Yes, I know there's a law enforcement correctional officer bill of rights that they're supposed to follow as well, but you have 72 hours to get counsel. If I come up to you as an investigator and say, I'm here to talk to you today about an allegation this inmate said that you beat him, and I'm going to read you your Miranda now. And you could say, well, I need to get counsel. I'm going to call Police Benevolent Association first. I want to get an attorney. That's your right.
Now, let me stop you right there. You're the investigator. You just read someone Miranda, and they say, I want a lawyer. What do you think of that guy? That correction officer that you're about to interview?
I personally, I can't speak for every law enforcement, I personally never had a problem with that. Because that's your right. That's your correction officer bill of rights. I fold up my file, and I say, Officer Jones, just so you remember, you got 72 hours to get back with me or your attorney or your counsel or your PBA, because we have to reset this interview for 72 hours from now. And of course, as long as they notified me, it didn't have to be exactly 72 hours. We could go a couple more days out, but let's set a date and time for the interview with your counsel. I never took it to heart. That's your right.
Here's the way every defense attorney looks at it, because everyone's like, oh, I look guilty. Oh, I got to say something. You know what it makes you look?
Smart.
Yeah.
Yes. Thank you. Yeah.
Because you're making sure that you're treated right, that what you're saying, and you don't realize. I'll go through depositions. I did one on another case recently, and I'm like, I could have swore this person said this or used these words, and then you get the actual transcript back, and it's not there. I have another case with a co-counsel, and we're doing the depositions where you bring in a witness and have them swear on, in front of a court-reporter prosecutor's there, and they give their statement about what happened prior to the trial. And the co-counsel thinks he's asking one question. You can clearly see that the witness is answering a different question, but my co-counsel wasn't asking the question in the right way, because I'm there and I'm witnessing it, and I'm, as you would in the bailiff, you're like, you're not asking what you think you are. And so I had to rephrase it and get it on point, and we did. And it happens to me. I do the same. We all do that. Right. It's human. And that's why having the lawyers going, wait a second, is that what you meant? Because you're going to talk to your client before you go in there. And then I had a case once, and we're mic'd up, so I'm not going to stand up and do it, but I'm reading the police report, and I go, well, then it says the guy was on the ground and you kicked him. He goes, yeah. I wanted to make sure that, he was, alive. And, so you all right, man? No, with my foot, I nudged him. I go, whoa. Well, the police report says, you kicked him. And he goes, yeah, I just nudged him to see if he's, and I didn't nudge. That kick, when the police officer wrote it, is you're winding up and you're kicking it like you're kicking a 50-yard field goal. And so if you have a lawyer there, when they're getting interviewed and they say, well, the inmate says you kicked him, and then it becomes, wait a second, what's your definition of kick? How much force is used? And having a lawyer there that's listening to this as you're giving a statement makes a huge difference on what word choice you're making.
Report writing 101. It's a lot of officers in corrections field, they're like, I really don't like writing reports, but there's so many reports you have to write, especially nowadays. And what you write on that paper is so important. Now it has to be the truth. I'm not saying be untruthful, right. But the words you use, like kick. If you write the word kick, we're thinking kick, like a football. If you write the word nudge, I'm thinking a lot lighter than kick. Please be truthful, but please use the right verbiage so you don't bury yourself.
Yeah, and we all do it. Here's another thing we do that people don't realize is, you ready, Gary?
Yes.
I took a pause because I'm doing this on purpose. Repeat what I just said.
You said ready, Gary?
No, before that, about something and people not realizing they're doing it.
Oh, you said we're all human and we don't realize we're doing
That's not what I said. See, if you go back,
Yeah. Well,
here,
I knew what you were doing, and boy, if you're not really in tune,
Right.
yeah.
and so that's the other thing is the words that you use are based on your experiences, how you grew up, how you've been affected. And you'll find it when I'm going through an audio, when we do have them on either, and I don't have a transcript yet, and I'm writing down, like if it's a DUI video, and I write down what my client said, you wouldn't believe the number of corrections because I'm putting in words that I use on a daily basis and they're not my clients. I got to go back, and that's why people don't understand. I had a trial, the video was 90 seconds. It took me 6 hours to get through that 90-second video. And so, because you're changing words and there were so many different theaters of action,
Right.
that you had to, okay, I'm going to watch the video from this perspective, then I'm going to watch it from this person's perspective and go through and piece them all together. And that's part of what I was saying. People don't realize the word nudge versus kick might be, your word for something is different than my word for it.
And great example because listening and staying in tune is important. I'm already thinking of another question for you or another scenario to put with yours, and I'm not quoting you correctly because my
Right.
mind is
Right.
all over the place. Yeah.
But that's the same thing with an officer who's writing down your responses. He's thinking about the next question. So in his mind the mind is unbelievably powerful. And you can't change their mind until they actually hear it and go, wow, I really thought that's what happened. I really thought
Right.
that's what was said. It's just how the human brain works.
And the same thing when officers are asked, there is an inmate that is throwing feces, throwing urine, and fighting. And the officers go in to stop the inmate. Now, this is a very high stress situation. And the attorney's saying, did you grab him with your right arm? Or did you use your right hand to grab his right arm and take him to the ground? And you're trying to remember, even after the incident is over and you have to write your report, you're like, oh gosh, everything happened so fast. Did I get his right arm or was it his left arm? These are all things that a lot of people don't take into account when you're an officer having to do these things.
But when you're the defense attorney, and I have the trial this week, we're going, what side of the face? What arm did he hit you with?
Right.
Wait, could he really have done that? Wasn't there a tree in the way? Or,
Right.
isn't he missing his right arm? So, how could he hit you with his right arm when he doesn't have one? And you're just, that's taking it to the extreme.
Right, but that happens, believe it or not.
You're doing something, and, that's happening, and you're reacting so fast in that we're coming in after the fact and, Monday morning quarterback. We're picking it apart. And so I got to be careful with the reports and why the truth, And if you got it wrong, you just go, it must have been my left hand, and I mistakenly thought it was my right.
Forget the excuses. That's the worst thing you can do. Just own up to it. I must have made a mistake then. If I didn't have his right arm, then I had the left arm. But leave it at that and don't try to wiggle your way out of it.
Yeah, he must have spun around, and then he was facing me the other way, I think, then, when I hit him and said, well, then what happens is, yeah, but your next sentence says X, and then we're going to tear apart how X doesn't fit with what you just tried to fix and try to make it look right. And meanwhile, the judge or jury, whoever your trier of fact is going, well, wait, that one didn't work. That was you just piling lie upon lie, and then they don't believe you. You're
Right.
losing credibility.
Right.
And that's what you make a mistake. I don't remember. Nothing wrong with an I don't remember answer.
Yeah.
And that's when clients come in and I go, what foot, if they're doing the one leg stand on a DUI, I go, what number were you at when you put your foot down? They're like, I don't remember. I know I put it down one time. Okay. But you're being truthful.
Right.
You're not trying to lie your way out of everything.
And instead of saying it was number 36 and prosecutors going to say, oh, you can remember that, but you
Right.
can't remember all this other stuff.
Yeah, and that's where you're gonna. If you're a good attorney, you listen, and that's one of the things people don't understand is a good attorney is gonna listen. And you give me gold, I'm gonna take that gold, I'm gonna run with it, and then I'm gonna crush you on it, and then I'm gonna come back right where I was, and I'm gonna go back to the line of questioning. But now I got this gold because you gave it to me, I normally wouldn't have had. It's gonna make my case.
Yeah.
And there's attorneys that don't have the experience or don't care enough or try or train themselves, then it just goes. You've seen it in court where you're like, that was it. I was watching a civil trial, and the guy, it's a train going across, and the guy's at the crossing, and the hood over the engine of the train comes flying off as it's going past the railroad crossing, and it hits his car, and he said he got injured by it. So the plaintiff, who's suing the railroad company for not having the roof secured to it, and saying, you were negligent not having the proper secure, the defense attorney asked the plaintiff's, the one who's suing, asked his expert and says, in 30 years, have you ever seen an accident like this before? And he goes, no, never seen anything like it. And then he goes, and so as part of the investigation, and he goes off on another, following along on what his cross was. It's like right there, you stop and you go, you've never seen it? No, not in 30 years? No, that's like a freak accident, isn't it? Yeah, freak accident, never saw it. You just won your case. It's over because you can't, in order to be negligent, you got to prove you knew it could happen. 30 years, you just get up and go, their witness, that's who you always want to build your case through, is the other side's witness. Their own witness told you it was a freak accident. You can't prepare and defend and be negligent if it never happened before.
Right.
But he let it go. He ended up winning the case, but you were done at that point.
Right.
You're like, it's a freak accident, move on, and you're done.
Yep, that's a great example. Well, I want to tell you, we covered a lot of stuff today, and I really appreciate you taking the time to sit here and discuss this, because a lot of the folks out there are going to really love this information. And I think anybody that watches what we discussed today is going to learn something from one of the things we talked about. And I love your real life examples that you use, because I'm big on real life examples, real life training, and I really appreciate it.
Oh, you're welcome anytime. Now, that's the other thing, is that it all goes back to how we learn. And that's one of the big things with psychology is, and another attorney told me this, he's like, he goes, after this video, just start paying attention to how many people say, it's like. So did you ever have frog legs before?
Oh, yeah.
I never did. What does it taste like?
I like frog legs. I'm going to say it's a cross between a chicken and fish a little bit, aquatic and chicken.
Right, but see, I don't know. I can't experience it. So the only way I can from you is telling me it's like an experience I've had. I've had fish and I've had chicken. So now I can, in my mind, I can go, you know what? Now I got an idea of what frog legs are going to taste like.
Right.
It's the same way anything you're doing here. So hopefully, that's why we use the real life examples, because people have been in those situations themselves every day where someone comes up to you and there's confusion on a text. What stress are you putting the word on? Why do you have wedding receptions? Why do you take your child to orientation? And people don't realize when they're coming to you out of nowhere and they're just going, someone comes to you, Gary comes to you in the prison, and he says, hey, we need to talk. Whoa, about what? Am I going to lose my job? Am I going to go to jail? What's going to happen to me? You're thinking about all of that, and they start asking you questions. You're not going to answer those well. You're not going to answer them thought out. You're not going to use the right word choice, because you're over here going, oh my God, what's going on? And that's why, relax. First thing, take a breath, and then say, I want my lawyer. And you look smart.
Yep, you sure do. Keep that advice, and I think if you heed this advice today, it will save you a lot of problems in the future. And let's hope you never have to use this advice.
Yeah.
That's the main thing. And we hope you never have to use any of this advice. But if you do, please use it and get yourself an attorney or a representative. Thank you very much, everybody, for watching today. And thank you for taking the time.
Be safe, everybody.